That's it. So, further notice to the Tri-County State's office withdrawn. Anything after this is non-negotiable. Brother. City versus Adams. We'll do a free trial. Come back to you. All right.
Judge,
Yeah,
just make sure everyone's on the mic.
I'm sorry.
Let me make sure that all speakers are on the mic for that.
Okay. Were you able to get the last statement? Ms. Jones, were you able to get the last statement?
She was very low, but I did see her.
All right, folks. Focus on the Zoom, and you'll need to be at the microphone that's actually working. I think that one might not have been working. Yeah. All right. No, she got, Ms. Jones said she was able, it was difficult to hear, but she got it. So, all right. Come on, Blaylock.
Good morning, Your Honor.
Good morning.
We received an offer from the state. I have he went to reject that offer.
You go ahead.
There was one other thing I wanted to just discuss with you. As I know, a motion in reference to the Plea Center on the original trial. In order, that motion was filed. If I'm not mistaken. I get that motion. I never received notice of that order until June 11th. I filed a motion requesting for he reconsider that motion and allow me to be heard on that motion. There was things that I did want to bring to court's attention to at least put on the record. So I would respectfully ask the court if he could please set that for a day and I could be heard on that motion.
Okay. No. That I decided that based on the defendant cited no authorities for the proposition that courts require to have a hearing on the motion. So the facts and the circumstances that are on the transcript from the proceeding are clear, and therefore there was no merit to going back to allow the defense counsel to be able to orally argue and merit this motion. Second thing, we filed it in Odyssey, and what I understand, your information is correct. So that's what we're supposed to do, file it, and it's supposed to go to counsel. Well, I don't know why you didn't get it, if in fact you didn't get it. But it's more significant is the fact that Ms. Chambers, case manager, emailed you a copy, and you didn't file a motion until 11 days or thereabouts. After you actually had clearly had notice of it because you got sent to you, and then the Superior Court rules you want to make a motion of a reconsideration, you got to do it within 10 days. So even if you didn't get it under the normal Odyssey process, get it more than 10 days before you file a response. So it's on time. But, you know, this is apologies to the 4 times. It's just the same old song. And it wasn't good the first time. So with no disrespect intended, I'm not gonna just take a court time to allow somebody to come in to argue the case when the plea is clearly made and the facts aren't really in dispute. Therefore, that motion for reconsideration is denied. You further notice until the trial time.
Yeah.
Go ahead.
Just as it pertains to, that motion, I would say, so again, that, well, it's not essentially the seven recently.
Which I never really agree.
Yes, correct. Is so generally, the trial court is allowed to serve an individual, yes, upon a motion by the defense or the state that it could be granted on that basis. A motion to settle was heard on behalf of all the defense in this case earlier, which was denied. This particular day, either Mr. Blaylock or the state raised the motion. Both of us actually opposed. Mr. Blaylock and the state opposed that motion. There was no manifest, there was no finding of manifest necessity by the court, with no facts that the Honorable Judge Lanfield laid out to indicate manifest necessity on this particular day. The only information that Judge Lanfield put was that it served the best interest. To be quite frank, it would serve everyone's best interest to be settled in this case. However, there were no factual findings of manifest necessity, which is what is required for a trial judge to settle a defendant. There was no facts, there was nothing pertaining to the actual evidence in the case that was laid out as to justifying Mr. Blaylock's sentence. It was simply that failed in one day. He wanted medical treatment. Mr. Blaylock and I offered to lay his presence, offered an alternative to being severed. The court denied that and elected to sever him despite him, despite his discontent with that. And just ultimately, there were no actual findings. There were no findings based on the evidence being confusing, being prejudicial to Mr. Blaylock, and no findings of manifest necessity by the court. Just minor severance, without
What anything you just said now that you didn't put it in this brief?
I put most of that in the initial brief. Just the reason that people generally have motion, I'm sure that when people able to orally express certain things to you, I'm sure that I can have a chance to the state said, but also I can answer any questions that you may have, right? Taking up paper, putting everything in brief. So that's really why I want to be heard, just to, really be able to flesh out some things, answer any questions that you may have. If the honorable court stands by his ruling, I completely understand, I respect that, but I did just at least want to be able to.
So let the record reflect, you just argued the motion, and you haven't said change the court's mind. And so the motion.
Okay. Thank you.
Yes, sir. You can. We've got so many defendants in here, we'll have to, in the order of fashion, allow different defendants to excuse their time. Safe for sheriff. So, but you make excuse. Good day.
That's good, y'all.
Who is your counsel? Oh, Mr. Lalone? Okay. All right. Yes, sir. Mr. I think we received the email from Mr. Lalone, was it yesterday sometime or whatever, indicating that he had a family emergency and needed to be at the hospital with his father, was what we were told. I think the state was actually send a copy of that email as well.
Yes, Your Honor. It's like,
I am, Your Honor, I just trying to make counsel in the,
Would you get on the microphone for us? Would you, come on, man. You know what? I'm trying to do the best we can. Yeah. All right, that's fine. We will see what's what. All right. All right. Yes, sir.
Judge, as I was saying,
This is this. Ms. Gentleman, did you get counsel's name? Have him spell it for you if you need to.
but see,
Your Honor, it appears that Mr. Luamba is the attorney in position number 5 and number 8, who would have been Justin Cobb. So here's that.
Okay, well, we done got them yet, so you have to see, okay? All right. Your attorney is assigned to you. Now, whether or not y'all have had any in-depth discussions or all those kinds of things, I hear what you're saying. You indicate that you don't even know who they are. And I appreciate what you're saying, all right? He admitted that. So we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is. I never can get the initial kind of thing straight, but when a request is made for an attorney to be appointed to represent defendants, it takes forever for them to get somebody and put them in place. Which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare and handle a particular case. This case has been going on so long that certain defendants may have had one attorney and somebody left the PD's office or somebody left the Georgia, whatever they call counsel of defense lawyers or whatever it is. And then somebody else has to be appointed and then come up to speed and all those things. Well, that's what we deal with. So what we do is the best we can do. So if somebody hasn't had a chance to adequately prepare or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today, his father apparently is in the hospital, and let me told something that's not true, and I don't have to believe. Father's in the hospital in a very serious situation. He's there with his parent. We'll look further into the idea of whether or not he's adequately been with you to do what he needs to do to represent you in this case. So that's the best I can tell you right now. And you may want to hear what the rest of what's going on. You would if you stay, still it out, then we can do that now. The sheriff is able to do that. Okay.
It's fine. Open it.
Yes. Next is, state versus Manhattan. If you, yes, please.
Morning, Judge. Attorney Dale here for Wisdom and Lord. I don't have discovery yet. I am going to get it in different places, but as soon as I get it, I'll do my best to get it ready to stop.
You were just recently appointed,
Yes, sir.
but that's what I'm saying to deal with. So, yes, we'll hold this one open as well, till I. Okay. All right. Then, we'll leave it open. Continue to come up.
Yes, sir. I'll get it straight.
Yes, sir.
Judge, can we get him a second for his name for me, please?
Yes, M-E-N-G, last name L-I-M.
Thank you.
Thank you.
Yes, sir. Jarvis Bradley.
Morning, Your Honor. Mr. Bradford, Mr. Bradford, and offer has been paid by the state, and Mr. Bradford is just now for we would like to further notice the charge.
All right. For the notice of trial. Okay, now we're on this.
Again, Your Honor, as mentioned, I've shown that I was receiving. It's, yeah, to seek discovery. Additionally, I have yet to receive a free line. Your Honor, unfortunately, I've been unable to get some type of time on it. On section, clerical error that Counsel says that. So I'll have to go to third.
Your Honor, the top of the husband of the board, states, Your Honor, is that the rest of this time why there is no answer.
If you've been, I'm not saying since we started, he not, he hasn't been in custody yet. Where, unknown.
Yes, Your Honor, the last bit.
I have seen in the history on see that he might have been returned to Washington State Prison. I checked the database.
I don't believe we aren't showing that. That's else.
No, Your Honor. I will.
All right, well, unless you leave before the court, and there's nothing we can do about Mr. Cobb's case, I would just say, stay ready to be brought into custody or whatever, and start from there.
Please speak.
Yes, sir. Right, well, you did make a official entry of appearance at that. Okay, thank you. Mrs. Mandel.
Good morning, Your Honor. Nicole Fagan on behalf of Mr. Mander. He has been relayed a message He is rejecting the plea at this time and further notice to the trial.
Ms. Jones, did you get?
Thank
No, I'm, court, I was making sure you get it. I know who you are. All right. And we'll further notice the case to the trial.
Thank you.
All right. And next will be, Mr. Winfrey. I don't see. Hey, oh. All right, Mr. Francis filed a leave of absence. He's out of the country currently, so I have permission to speak on. Yeah, briefly, go ahead.
Yeah, on the record, on Friday, we had to deal with court responded would be no type of way with this case to be changed to the final plea. And as one lawyer, I'm struggling back. So I would like to change
Okay.
You know, the court.
Yes, sir, that's true. Are you asking to be able to get someone else appointed, or are you saying you have the resources or you intend to hire private counsel?
Our private counsel, I like to be appointed.
Okay, well, let me make sure we're on the same wavelength. What I'm asking is, our understanding was that you were indigent, not able to afford the hire. Okay, and the question is whether you can hire a private counsel or get someone appointed to be either you end up having to stay with Mr. Francis or you're able to get someone. I understand what you are asking, and we'll take that up at a later date, because we need to have him here to be able to get Mr. Francis. But then, I guess what you got appointed right before the last time we went forward.
Yeah, that's still don't give them no right now to court.
Sir, I'm not disputing what you're saying right now. Okay, I'm just saying I need to have him here so we can know the reason why he hasn't been able to contact you or go forward with you. And unless and until we find out, we're not gonna just give you another lawyer.
Well, I have my family retained when I want him on.
You're free to do that anytime. You're free to do that.
I'm doing that now on the record. I don't want him as my attorney.
Okay,
You know,
I hear you.
9 days.
I hear you. I just said I'm not gonna deal with that until we have an opportunity to have it.
Yes, sir, I understand what you're saying.
Okay, I got you loud and clear. Yes, okay. Okay, so Mr. Winfrey is remain open with you because counsel isn't here anyway. We need to make a change. The court will look into that matter as to whether or not there's justification for doing that or not. And in the meantime, if your family wants to hire counsel, then they're free to do that. But airing out between them doing that, but airing opportunity. That ain't gonna stop them. And opportunity is still there. So if that happens, then you let them make an appearance and then they can represent going forward. All right. Yes, you can.
And we are not somebody.
Okay. Further notice to the trial, Kelly. All right. Maybe. All right. There's nothing further. Anything from the state?
But
This one is Frank, will come over and
Okay.
Yes, the one that is not the name of it.
Yeah.
All right, Mr. Jones, that's it. We're done.